Hi folks, it's John Bandler. I'm answering questions on Cyberlaw and my Cyberlaw book. This video, April 2nd, 2026. It's on intellectual property, chapter 28. And I'm helping out an instructor who's teaching with my book. So this is obviously not for a course I am teaching. And law is for everyone. Cyber's for everyone. That means cyber law is for everyone. And these are quick and off-the-cuff answers. It's not a polished slide deck. I haven't rehearsed it. I haven't spent hours thinking of the answers to these questions. So when I build courses with the weekly assignments, at the end, I'll encourage students to ask a question. And that's happening in this course too. And some of the questions are being passed on to me. Just remember the book. We have these foundational parts of the book, which I think are really helpful. And then we get into the meat of cyber law, and we're in part 5 of the book now, and that's what the questions pertain to. But just want to remind you what the course is like. Don't forget the chapter resource pages. Anybody can access them. They're on my website, including this one for intellectual property law. Gets you to additional resources, the actual statutes. Disclaimers for this video, pause if you like, but I may make some mistakes because I'm doing this quick. All right, so here's a question. Since sports leagues like the NFL claim copyright over game broadcasts, does a fan posting a highlight clip on social media constitute infringement? And how does fair use factor in given the commercial nature of the leagues? Now, as always, as I give you answers, a little bit is my opinion, and I'm not a judge in a case, so we have to remember a lot of times there's no magic answer to legal questions. Every case is different. There's different facts, different plaintiff, different defendant, different attorneys, and importantly, different judges. Judges are humans, and they decide the case. So what we want to do here is analyze what each side's arguments might be. Now, in your question, you talk about the commercial nature of the leagues. We want to kind of take that as a given, right? And that's a reason they put that copyright protection on it, because of that commercial nature, right? Those broadcasts, that's worth millions of dollars, maybe even billions. So what we want to think about is the potential commercial nature of what that fan is doing when they post it. And we want to analyze what each side's argument might be. And I guess we'd start with the NFL, because they would be the plaintiff, right? So what's the NFL's side? First, we look at whether they care or not. We ask, hey, does this clip, the analysis by the fan, I guess they're putting on YouTube or TikTok or whatever, does that help the NFL or hurt the NFL? Now, the NFL might look at it and they might say, hey, this is good. This gets fans interested in the games. Maybe they'll watch the actual game or do something else that benefits our brand and our business, right? Fantasy football. That's benefiting someone somehow. You look at who's making money, and all these other things the NFL is looking to protect their business. Next thing they look at, if it hurts them, is it worth the effort to pursue? Because it costs them time and money, and there's a public relations impact too. Now, if they decide they want to pursue, what would their legal argument be? They would say this clip is an unlawful copy of their copyrighted video broadcast. They would say it's not fair use, because they know the defense is going to be fair use. They'd say it's not fair use because, what might they say? Oh, this fan, this YouTuber is using too much of it. They're doing it to earn a profit. They're not just doing a short excerpt to comment on it, what might be allowed by fair use. They're using it so that to substitute people get watching the actual game. And how would the YouTuber be profiting? Clicks, views, advertising, all that. What would this fan or the content creator say? They'd say it's fair use, it's a limited clip, It's transformative, and the purpose is showing that short clip so they can provide commentary on it, and that the commentary is the main part of their clip. That's how the arguments would go. And we can see the different extremes where we would agree, like if it's a tiny clip and a lot of commentary, we'd all agree, hey, that's fair use. On the other hand, if it's a half an hour of the football game with just a little bit of running commentary, we could see how that fair use defense would not apply. And then there's all those areas in between. Question: additionally, considering how the internet has made the world increasingly interconnected, is it realistically possible to enforce trade secret laws against a company in another country that independently uses the same formulas or business approaches, especially when the companies are not related or subsidiaries of each other? So I guess first thing, we remember the elements of a civil claim for trade secrets violation. So in your question, you mentioned independently uses. Just remember, to have a trade secrets claim, you have to show wrongdoing. So if they independently are using it without wrongdoing, without misappropriation, you wouldn't have a trade secrets claim, right? You have to show that wrongdoing. Now, the other part of the question, enforcing something against someone in another country, that's always going to be especially difficult. But we also have to remember how hard it is to enforce your rights even within this country. And that's one aspect that runs through the book. And when I talk about law, the theories of law are beautiful, but the practical realities always get messy, right? Because when you're bringing a lawsuit, each side is fighting against the other. And sometimes it's downright nasty and ugly, and it is always hard to enforce one's rights in court, and especially so if the person's in another country. Sometimes it's almost impractical or impossible to enforce civil rights against someone in another country. One question I have, this is related, that's why it's on the same slide, is how often companies actually enforce trade secret protections in court compared to patents or copyrights. It seems like many organizations rely on internal security measures and NDAs, meaning non-disclosure agreements, rather than legal cases. So yes, remember, it's costly, it's time-consuming, it's stressful to bring a lawsuit. And that's why most people try to avoid it. Good lawyers try to avoid it, even though some lawyers only litigate and they love to litigate. But a good litigator, an ethical litigator, may say, look, it's in your interest to try resolve this without a lawsuit, because if you hire me, it's going to cost you $10,000, $100,000, $1 million. A lot of companies and individuals want to avoid a lawsuit. And then remember, the heart of a trade secrets lawsuit is you do have to have those internal security measures in place in order to prevail on a trade secrets case, in a measure including an NDA. If you're not protecting your trade secrets and they get out, you may not even be able to bring a claim. And of course, the whole object of trade secrets, keeping secrets, is that you want to keep them from getting out in the first place. And then the legal protection comes when you made those efforts to keep them from getting out. You were diligent, but someone did something wrongful to get them nevertheless. And that's when you can bring a lawsuit. Doesn't mean you're going to bring it every time, but you could. Next question. What type of consequences can an organization suffer from if an employee were to disclose trade secrets? While the company would suffer in a few different ways for this, I would assume the biggest consequences would get placed on the employee in this situation. So I think you're talking about an employee who violates the employer's rule, the organization's rule, and then the employee wrongfully discloses their employer's trade secrets, right? And we have to remember there's cascading series of consequences. There's consequences for the organization, and you would assume consequences for the employee. If that trade secret gives the company a business advantage over their competitors, They just lost that advantage, right? If the trade secret gets out, they don't have the advantage of the trade secret anymore. That means what? They're going to lose revenue. And maybe they lose a lot of revenue. I guess it all depends on how important that trade secret was and how much their competitors take advantage of that. And in some circumstance, that could mean millions of dollars, right? It could mean the end of the business. So that's the consequence to the organization. And then you would think there'd be a consequence to the individual if the organization decides to go after the individual, and that could be a range of consequences. That individual could be subject to criminal prosecution if they violated a criminal law by stealing those trade secrets or selling them. That could violate a criminal statute, and we saw that in an example we talk about in the books. That's the Goldman Sachs case with that source code that Goldman Sachs said was stolen, and then the guy was subject of a federal prosecution and then a New York State prosecution. The individual could be sued by the employer, right? They could bring this claim, the trade secrets civil claim, and say, you stole our trade secrets, and therefore you're liable to us for whatever amount, $1 million, $10 million, $100 million. And then that civil lawsuit, you see how it resolves. Obviously, the employee might deny it. And then the employee could be subject to discipline, including termination, right? Because that's part of protecting your trade secrets, that you let employees know they have to protect the information, and if they violate it, they could be disciplined up to and including termination. Obviously, if the organization's going to try to get the person prosecuted criminally or sue them, obviously they're going to terminate them also. But for more minor infractions, it could be a lesser punishment. Next question. Given how AI, artificial intelligence, has transformed content creation, information generation, and distribution, I wonder whether copyright laws and intellectual property in general are evolving quickly enough to keep pace with these changes. Are current laws adequate to address the challenges posed by AI-generated works? And I've got a couple similar questions coming. So first, what I want to talk about is remember how we introduced this concept in Chapter 2. I call it a misconception. It's even a myth about cyber law, and that is the myth that the law is behind or the law needs to catch up. And we want to put that in the context that the law is always evolving and plaintiffs and defendants are always bringing new claims or defending in new ways. So we want to just remember, we can't think that we could snap our fingers and catch the law up and then people are happy that the law is caught up. So we want to consider realities, foundations of law, complexities of law, and people. And whether the law moves quickly or slowly, we got to realize there's going to be some people really happy, some people not happy, and there's just no magic answer. And we got to remember it depends on your perspective. So if you're an AI company and you are now making a lot of money or putting these tools out, you've invested millions of dollars or billions of dollars in your AI technology and your business model. If you're the company or you're an investor in that company, you put your millions or billions of dollars into it, or you work at an AI company, I think you're saying, hey, the law is good because so far, at least, it's allowed us to do what we're doing, which is suck up everybody else's copyrighted works and use them to train our LLMs, large language models. So if you're in that camp, you're kind of happy with where the law is and you don't think it needs to catch up. If you're a creator or publisher, I think you're feeling maybe not that the law needs to catch up because you're saying, hey, the law is there. Copyright law says you cannot do that. It's just that you're bringing your case or the case is getting through the courts and a judge has not yet stated that the copyright law is being violated when these AI tools do that. And we're going to talk a little more about this because There's no magic answer yet on what the law says. It's going to be up to judges. Judges are human, and we're going to see how people are trying to influence the law. These AI companies who've put billions of dollars into their business model, they're not just going to accept that the law says don't do it. They're working to get the best outcome in court and to get the government to do things that protects them. So again, this whole perspective depends on who you are, what side you are in the legal case, or which side you would be. And I'm going to address more of this with the next questions. The rapid growth of artificial intelligence and generative AI tools, how do you think intellectual property law, especially copyright and trademark law, will continue to adapt? For example, there are ongoing debates about whether AI-generated content can be copyrighted and who should own the rights to it. I'm curious to hear your perspective on how courts and lawmakers might handle these issues in the future. Trademark, listen, if you're doing AI-generated content and you're copying someone else's trademark, hard to see how that's going to be okay, right? If you're trying to trick people into thinking you're that brand, I don't see how that's okay. But I think copyright is the issue we're seeing, because the AI companies are saying it's okay to use that copyrighted material to train their models and put out output. But creators, authors are saying, I don't think that's fair. Similar question, how intellectual property laws, especially copyright and trademark, will continue to adapt, evolving quickly. How future regulations will address the changes. So, we don't want to be talking regulations. We want to think, I guess, be a little more precise. How will the court cases come out? What will the court decisions be on these cases that are pending? And what will the future laws be and executive orders? First, with both these questions, let's remember there's law there. So let's first look to the law, the copyright laws. Let's see what the statutes say it protects and what it doesn't. It says it protects an original work, right? So it has to be an original work to get copyrighted protection. So if it's not an original work, the argument is it doesn't get protection. It has to be from an author. And there are lawsuits pending in the courts, and we're going to get court decisions to see how each of those judges rule. What we're also seeing is that the AI companies have a lot of money, and the investors in the AI companies have a lot of money on the line. They've sunk hundreds of millions of dollars into it. They want to get their money back, and how they influence the law can influence how much of their money they get back. We're seeing attempts by the White House to limit how states can legislate on this. And because the White House and people in the White House and family and the government and campaigns have gotten a lot of money from AI companies, we're seeing that they're trying to support AI companies with how the law develops. And we saw similar things with crypto companies. And that is the ugly, nasty side of the law where money and power can influence how it evolves. Let's say you give copyright protection to output from generative AI tools. Let's say people are trying for that. I actually don't see how that sustains itself, because eventually you get to a contradiction. Because if you're saying that an AI company or AI tool can take human authors' original work, suck it down for free without compensation, and regurgitate it or mix up the words a little without compensation, it's hard to say how that regurgitation would get copyright protection. And then when other people, regurgitate other versions of that, it's hard to say how those regurgitations would get any copyright protection, because either you're not giving anyone copyright protection, or you can't give everybody copyright protection when they copy it and just spit it out a little bit different. And that brings me to something else on AI tools. Yes, we've got the copyright issue, and that's what we're covering in this chapter. I just want to remind you how we talked about it in Chapter 3 in the context of student learning, and how I wrote this book with the intent that students could be expected to read every word in the book, and that students would never have to use an AI tool to summarize what's in the book, because I deliberately wrote this book in such a clear and simple fashion that it would only get worse if an AI tool is trying to regurgitate or summarize what is in the book. And we talk in Chapter 3 about how important it is for students and all humans to build and exercise their brains. And we have to think about what AI tools are doing to humans, including students. I think there's a lot of impediment to brain development and human education when students are using the AI tool as a shortcut. Because the traditional education model, which has a lot of merit, is where the instructor assigns reading and assigns maybe a prompt with thinking and writing. And traditionally, before AI tools, and still the proper way to do that is do the reading. And the reading might take an hour or 2 hours. And then read the prompt, and then do some thinking, and then do some writing, and do some editing. And that might take another couple hours. Schoolwork is supposed to take hours of work. A week in a course, college level, graduate level, law school, like that's supposed to be hours, 4 hours, 6 hours, 8 hours of work. And in those hours of work, in that struggle, that's when learning and brain development and your skills get improved for reading, thinking, writing. And there are students taking that shortcut. And in this video on YouTube, I'll put a link in the description, I talk about how that shortcut really gets you to a different place. It gets you to a place where you haven't done the learning. Yes, you got the assignment done, but instead of doing those hours of work to get the assignment done, you did a couple copy and paste actions, maybe a cursory review, and there's no learning value of it. You got the assignment done in 2 minutes, but you're not getting the learning. And it scares me to think what happens in a country if people's attention spans and ability to think and analyze decrease because they're relying on AI tools to do a lot of things for them, and they're not exercising their brain. And add that on to AI companies if they are not properly regulated by the government. What they output is now influencing people. And we get into that more in Chapter 36. So I hope you're looking forward to that. Thank you so much for listening and watching. If I answered your question, let the professor know your next assignment submission so they know you watched this. If I didn't answer it to your satisfaction, feel free to put a follow-up. Find another way to let your professor know you watched this. And remember, law and cyber law for everyone. I'll have links in the description, including where you can learn more about cyber law. Always start in the book and see my chapter resource page. Thanks again for watching. Don't forget to like and subscribe. Take care.